Order, order. Well, good afternoon, everyone, and welcome to today's meeting of the Joint Committee on Human Rights. We're a cross-party committee and also a joint committee, which means we have members of both the House of Commons and the House of Lords. And our focus today is the Bill of Rights Bill, which was introduced in the House of Commons on 22nd June. The date for the second reading of the bill has not as yet been set. And we are happy to have with us this afternoon the Right Honourable Dominic Raab, Deputy Prime Minister and Lord Chancellor. Good afternoon, Lord Chancellor. We're very pleased to have you here, and we had hoped to see you 5 months ago, but nevertheless we welcome you today and thank you for coming. Before I ask you any questions about the Bill of Rights, can I just ask you about something else? It's been reported today in The Guardian that you blocked the reappointment of the Victims Commissioner, Dame Vera Baird. Is that report accurate?
Well, I'm responsible for the appointment, and as you know, we've been engaged in an open competition, and I refreshed the open competition because I wanted to get the fullest and strongest field within which to choose. And I think that's the right thing for such an important role. I know there's always that balance between doing it swiftly and doing it as comprehensively as possible, but my view, particularly with the Victims' Bill and the changes that were being made, is that it was worth a wider trawl to attract the very best and widest talent group for such an important appointment.
Okay. My understanding is that she stepped down in September after being told in July that she wouldn't be reappointed. Is that correct?
I'd have to come back to you on the specific dates,
right.
But we made clear we would go out to open competition, and again, as I say, I'm conscious of the need to fill the post, but I think it's right to make sure we do the very best field of candidates that we can, and I'm confident we will.
Is it accurate that she wanted to be reappointed but was told she wouldn't be? Is that accurate?
No. But you'd need to speak to Vera about what she wants to do.
Well, can we ask you to clarify that for us in writing, whether whether she wanted to be reappointed and whether she stepped down in September after being told in July that she wouldn't be reappointed?
I think in terms of her intention, you need to go to her, but I can tell you that I certainly did not tell her that.
Okay. The post is vacant at the moment. When do you expect to fill it?
Well, again, I'd need to look at the dates, but we're in the middle of the process as soon as possible. I accept it's an important role. I want to fill it as soon as possible.
But it's been empty since September?
Yes.
Right. And I think in her resignation letter, Dame Vera Baird said that the criminal justice system was in chaos and accused the government of downgrading victims' interests. What's your response to that?
I think that's demonstrably wrong. It maybe reflect the fact that she had hoped that by then she would be reappointed, but I can't speak to that. What I can tell you is that with the Victims' Bill, with the quadrupling of funding for victims since 2010, with the whole range of stuff we're doing for violence against women and girls in particular, from the national rollout by, I think it's the end of first quarter next year of Operation Soteria, the 24/7 rape support line, with the Section 28 pre-recorded video evidence now nationally rolled out. I think we have made very important strides, but still more to do.
Do you agree with me it's a bit unfortunate that while all this critical legislation is passing through Parliament, there's no independent Victims' Rights Commissioner in place to scrutinise it from the victim's point of view?
Well, that's true. We have lots of others who provide comments, but I'm not going to downgrade or diminish the importance of the Victims Commissioner. Far from it. It is precisely because of the importance of getting that appointment right that we are going through such a rigorous process, and I hope that that person will be in place shortly, and of course they will have the opportunity, as in fairness, Vera Baird has until recently, in terms of the victims' clauses of the bill, which have gone through pre-legislative scrutiny, to provide us with that important feedback.
You said you hope to fill the post shortly. The Guardian reports that the post is expected to remain vacant until spring of next year.
I'd have to come back on that, but that's not come from me.
Do you agree with me it would be regrettable if the post remained empty for several months?
I want to get it filled as soon as possible, but I think the most important thing is to get the very best candidate.
My colleague David Simmons wants to come in.
Yes, thank you, Chair. I just think it's important. I certainly wasn't aware that these questions were going to be raised. I think important as they are, I just think for the record I'd like to say I think these questions are not being asked on the basis of evidence that we've taken as a committee. But clearly, reports in The Guardian are reports in The Guardian. I'm sure the committee could consider the matter, take any evidence and perhaps raise some further questions in due course.
Well, as you know, the committee would hope to do that, but we can't take evidence from the Victims Commissioner if there isn't one in place. But your point's duly noted, David. Thank you. Maybe we could move on to the Bill of Rights, or should I call it the Bill of Rights Bill? It's nearly 6 months since you published the Bill of Rights, Lord Chancellor, on 22nd June, and it's 3 months since the second reading was pulled just before 12th September. And we've now got the House of Commons business up until the Christmas recess, and there's no sign of a second reading of the bill. Can you tell us when the bill will receive a second reading?
We're ready to go. The bill has been published, and of course, all the more time for scrutiny and consultation, so we can use that time valuably. But particularly with the change of government, the centre, if you like, but it's a collective effort, need to decide the sequencing of our priorities, and the Prime Minister has addressed this today, and I fully support that sequencing. But we're ready to go, the Bill of Rights is ready to go, and we look forward to bringing it forward for second reading and engaging with your committee and with members of both houses.
You can't give us a date?
No, I haven't been given one yet, but as I said, we're ready to go with it.
When it does come to the Commons, is the plan to take it to a committee of the whole House?
Yes.
Thank you. Just looking at the history, which you've alluded to there, and I alluded to as well, it was published on the 22nd of June. You were due to give evidence to us on the 20th of July, but you pulled out of that. And then we expected a second reading of the bill on the 12th of September, and that was pulled by the government headed by Prime Minister Truss, Liz Truss, the Right Honourable Liz Truss. And then on the 14th of September, you were due to give us evidence, and you cancelled again. And then on 17th October, the Lord Chancellor appointed by the Right Honourable Liz Truss, Brandon Lewis MP, told us the bill had been paused and they were looking at it again. There was a Westminster Hall debate on the 24th of October when the junior minister told us, and I was present, that the plans were now just to review and update the Act, and he reminded us that the Conservative manifesto didn't say that you were going to repeal and scrap the Human Rights Act. And then the day after that, on the 25th of October, you returned to office as Lord Chancellor and announced on Twitter that the bill would have its second reading in the next couple of weeks. And I think you confirmed that to us, to this committee, by a letter dated 14th November. And then on the 22nd of November, you told the Commons that the bill was going to have a second reading very shortly, and that you were close to agreeing a timetable with Commons business managers. And then on the 8th of December, the Daily Mail reported that Number 10, and I'm using their language, had kicked the bill into the long grass, and the Times said that the bill had been deprioritised, but that you were trying to convince the Prime Minister that the bill was crucial and that several other proposed laws hinge upon it. Now, I'm going through that timetable because it's a bit tortuous, and I think it's fair to say there's been a bit of a hokey-cokey with the bill since it was first published in June last year, and it does seem that 3 different Prime Ministers and many of your colleagues are not very keen on the bill. I mean, it's very much your personal baby. Is it a bit embarrassing for you, the lack of enthusiasm from your colleagues?
No, not at all. Look, you can cite newspaper reports of this and that. The reality is both Prime Minister Johnson and Prime Minister Sunak are committed to the Bill of Rights, and I'm delighted we'll be taking it forward.
The reports in the Times that you were arguing that the bill was crucial and several other proposed laws hinged upon it, are they accurate?
Look, I'm not going to comment on tittle-tattle in newspapers. It's just not. I'm here to answer your questions to me.
Fair enough.
On any of the detail.
Let me put my question to you then. Would it be correct to say that there are other proposed laws which hinge upon the repeal and replacement of the Human Rights Act?
We've always said if we want to deport more foreign national offenders, if we want to strengthen free speech in the way we've described, all of these things are things that a Bill of Rights will help us deliver. I've been clear in the past that I think we will have a better chance of delivering some of the more concerted parole reforms if we have the Bill of Rights. Separation centres in prisons with this issue of terrorist offenders increasingly claim a right to socialise under Article 8 is something where we've already got claims being made. Again, that's something which, frankly, just shows you the material benefits of delivering the Bill of Rights. So I do think it's important for a whole range of the policy aims that the government has, particularly in terms of public protection, but also some of those other areas I've touched on.
Yesterday, the Prime Minister announced in Parliament that he was going to be bringing forward in the new year a package of immigration legislation. Do you think it would be important, or do you think the success of that legislation would hinge upon repealing the Human Rights Act and replacing it with the Bill of Rights?
I think they have a crossover, but we'll want to make sure that the legislation that comes through on small boats is self-standing. But the Bill of Rights will assist. I want to be clear, it will assist in three particular ways, but I don't think the Bill of Rights would resolve on its own the small boats crisis, and I've always been very clear. But I think with the approach to interim orders, I think the curbing of the more creative judicial innovations, and in particular the repeal of Section 3 of the Human Rights Act with the ability to effectively amend legislation through the courts being licensed effectively to do so, and also
the interpretive obligation you're talking about.
But effectively to read down legislation without Parliament having any scrutiny. And I think also the provisions in the Bill of Rights in Section 7, Clause 7, all of those three I think will materially help to protect within the margin of appreciation and the bounds of the what's permissible under the ECHR, greater border controls, and I think that would at various points help with small boats. But I certainly support the Home Secretary and the Prime Minister in bringing through the small boats legislation that will be coming in the new year. I think from a human rights point of view, can I also just say that if we look at the appalling tragedy that we've seen today, I think that just shows you how this will be a human rights enhancing measure, and why we need to be looking at what is going on in the Channel and with small boats as a human rights, I would say, not only a disaster when we see incidents like we have now, but the recipe for far more humanitarian loss of life. And the measures we're taking, I think, will help protect human rights for precisely that reason.
What measures will be human rights enhancing?
Measures that stop this awful trade and people taking these appalling risks which can lead to tragedies like we've seen today.
So you're saying that you're talking there about the organised crime and the smugglers?
I'm talking about it in the round. I think we need to deter at every level, consistent with, of course, our international obligations. We take those very seriously. The attraction of coming here illegally, taking the kinds of risks we've seen, and the criminal gangs with their business model that prey on them. And I would have thought that was really clear, and graphically so, and tragically so, from what we've seen today.
Do you think that the Prime Minister's proposals and your Bill of Rights will enhance the human rights of asylum seekers?
Yes, overall, I think they will have exactly that effect by discouraging perilous illegal routes, and B, with the emphasis he's put on the importance of international safe routes. I mean, I think, I was very proud as Foreign Secretary to pioneer with the Home Secretary at the time, Priti Patel, but also the current Prime Minister was Chancellor, current Immigration Minister was the Secretary of State for MHCLG, as it then was, the Hong Kong B&O package that's been taken up. I think that was a really important thing to do. Likewise on Ukraine and Afghanistan. I think we've shown, and I say this as a son of a refugee, that we have a compassionate history and heart as a nation, welcoming those who flee persecution. But I think that is put at risk, both with public confidence, but also in practical operational terms, when you have these chaotic illegal routes. And so stopping those, I think, is much, much safer, and in the way I've described, is much more, if you look at in aggregate, is going to enhance human rights for this country and internationally.
I don't want to stray too far into what's the provenance of the Home Affairs Committee, but I need to challenge you on a couple of things there. We know that there's no Ukrainians or people from Hong Kong on the boats crossing the Channel because there is a safe legal route for them. But we know that for people from other countries, asylum seekers, there isn't any safe legal route for them to come to the United Kingdom. And there's talk of more safe legal routes, but we've not been given any detail. So would you answer the question that the Home Secretary was unable to answer, which was that if somebody wants to come to this country to claim asylum, and there isn't the kind of resettlement schemes that we've seen for Ukraine available to them, what is their legal route to get here at the moment?
Well, it's not just Ukraine, as I mentioned, the B&Os, but also Operation Pitting.
Yeah, but let's talk about a country for which there's no scheme in place.
Sure, but I think it's right that we focus our compassion on the most acute disasters. But it's a fair question, and of course the Prime Minister, when he set out the proposals yesterday, talked about this. We will work with the UNHCR to identify those most in need, and I do think that's an important thing to do. So we offer that safe haven to those who are most vulnerable, and our legislation will introduce a cap on the overall number set by Parliament in consultation with local authorities, and that's the way that we will do it. I think that's also a better way in terms of encouraging integration for those that come here. I was very recently, I went to Cobham Free School in my constituency, and I was very struck by 3 B&O children and their mother. I think the mother actually may work there, who came and approached me to thank the UK for our generosity.
I'm asking you about people for which there's no established scheme. I'm not querying the fact that it's good to have established schemes. What I'm asking you is quite a precise question, Lord Chancellor. For people from countries for which there's no established scheme, who want to come to the United Kingdom to claim asylum, what's the legal way for them to do that at present?
Well, I've just said that's what the legislation will address.
There isn't a way at present. If you need legislation to address it, there mustn't be a way at present. Is that right?
No, the Prime Minister was clear. It's been done ad hoc, if you like, in recent years, and part of the package of measures, as well as clamping down on the illegal routes, is to clarify the more generic way that this will be done, rather than just country by country, and there will be legislation with a cap, but it will be done in consultation with UNHCR, so we can focus on those areas where they think A, there's the greatest need, B, where the burden sharing is most appropriate, and we can also do it in a controlled way with local authorities because of that integration piece that I was touching on.
You're talking about the future. At
Yes.
present, you're unable to point to a safe legal route for someone wanting to come to the United Kingdom to claim asylum if they're not from one of the countries for which there's a designated scheme.
I think it is legally possible, but I ought to defer to the Home Secretary.
How is it legally possible?
Well, you can claim asylum in different ways, but the truth is,
You have to be in this country to claim asylum. Isn't that the law at present?
I should.
So how do you get here if you're not from a country with a scheme?
What I wanted to do is set out the proposals for the future, but it's not for me to discuss the current asylum arrangements. That is for the Home Secretary. I'm sure she'd be willing to write to you if you need further detail.
Lovely. I'm going to bring David in for a question, then we'll go back to the Bill of Rights.
Thank you very much. Thank you very much, Chair. I entirely agree and support everything that you've said so far about the future and the way the scheme works in respect of existing safe and legal routes to resettlement. I think one of the frustrations for the committee, when we took evidence, I think, on the Nationality and Borders Act, was we spent some time on this question of the relationship between safe and legal routes and the ability of the UK government to consider a claim to be either disadvantaged or inadmissible because of the means by which someone came to be in the UK. So we know, as the Chair has outlined, you cannot lodge your application for asylum in Britain unless you are already physically here. And I think it's a commendable ambition that the UK government wants to break the cross-channel smuggling route by saying if you come by a route which is irregular, then that would disadvantage you in lodging your claim.
Yes.
But at present, that will always fail because there is no alternative route by which those people could have lodged their claim. So I think the point being, and I think probably even the European Convention on Human Rights may not be the key issue, a British court would take the view, outside of that, that if the system had frustrated any possible means by which someone could lodge a claim, then that factor had to be set aside. So I think the question then becomes, what will be the safe and legal route by which someone who is currently in northern France with a family member in the UK can either lodge a claim or even seek permission to travel to the UK to lodge a claim at an asylum centre at the UK border in Calais or at a consulate anywhere else in the world, in order that there will be an alternative to getting in a small boat, which would in turn enable the UK government to say, if you come in a small boat, that will not be to your advantage. If you take the safe and legal route, it will be.
Yes, but I mean, again, I'm not going to comment on what judges may or may not decide, and I'm not going to do the Home Secretary's role. But all I would say is we have, of course, in relation to those that come from France, they've by definition come through either directly or indirectly a safe third country. And that is one of the problems here. That is not supposed to happen. But if you look at the crisis situations that we have addressed, I think of Afghanistan, and we mentioned Ukraine and Hong Kong, we have found a way to do it from either the source or countries in the region. But I accept that there is a problem with the situation in Calais in France. That is what the Prime Minister, the Home Secretary and the whole government is seeking to address. But I get the conundrum you're posing. It's just probably for the Home Secretary to answer your questions in more detail.
I just want to query something quickly and then we'll move back to the Bill of Rights. You said some people who in northern France have come through a safe third country and that's not supposed to happen.
Yep.
But there's nothing in the International Refugee Convention that says people have to claim asylum in the first country they come to, is there?
No, but that's been, I mean, our experience has been part of the Dublin Convention. I know that doesn't...
We're not part of the Dublin Convention because we left the European Union.
Of course. But it was happening well, but it was happening even before then. And I think there is an expectation now, whether it's custom international or I think is debatable. But certainly there's a moral argument that you claim and whether it's a legal argument, I'd need to check, that you claim your asylum in the first jurisdiction.
I assure you it's not the legal position, because I checked it yesterday before I asked the Prime Minister about it. But as to the moral argument, isn't there equally a moral argument that if we have people migrating across the world, whether it's because of famine, climate crisis or political oppression, it isn't fair to expect countries in the immediate vicinity of the problems to take all the asylum seekers? Surely there's a moral obligation for global Britain to play its part.
Yeah, but of course, I think that's right. But for example, whether it was Ukraine or Hong Kong, whenever we did the assessments, it's not a question of what we want. The vast majority of people travelling those distances, if they have to flee their home country, if they have to leave their homes, would prefer to be in a country of the region. That's clear from the migratory flows. But I think by the time, so I think that's the first thing. And in terms of the moral duty, I think there's a moral, look, I would say this, I've talked about my family history before. I think we want to be a compassionate country, but few countries have shown so much compassion proactively on Hong Kong and very swiftly on Ukraine and Afghanistan. But it's got to be done in a structured and orderly route. What I don't accept, Joanna, as a premise is that chaotic flows across such long distances with the UK, for all sorts of reasons, a natural magnet is the right way to do it. What you'll do is you'll lose public confidence. You will, and I saw it when I lived in the Netherlands for 3 years, when I was a diplomat on posting in the time of the murder of Pim Fortuyn. and the big raising of tensions, particularly with some of the ethnic minority communities there. And if it is felt by the public that there is not a structured, controlled way, if you do not have integration, which is why I talked about local authorities, the central party, the centre parties, start to get attacked from the fringe parties. Now, look, whatever our views, and we may differ on many things around this table, I think we all want to avoid fringe parties, some of which we have seen gain increasing traction in Europe.
I hear you, Lord Chancellor.
And if you want to maintain public confidence, you've got to show we can do this in a managed, organised and less chaotic way.
We could debate these issues all day, but we really need to get back to human rights, which is what this committee is concerned with. And I want to get back to asking you about the Bill of Rights. Now, in fairness to you, I think you've been working on this Bill of Rights for many years. It stems from a book you wrote over a decade ago. And I think it would be fair to say that it's very much your baby, the Bill of Rights, isn't it?
No, it's been in. Look, I've thought about it a lot, but it was if we want to be precise about it, it was in the 2010 manifesto. It was in the 2015 manifesto. We talked about it, albeit in a slightly different version of the language in the last manifesto. And I would challenge the assertion that the Human Rights Act got everything right. And also, I think it's a very British thing, not even just a conservative thing, that human rights is a journey that we're on from Magna Carta right the way through. It's not a transaction where it's just done, and we look to write the next chapter true to our traditions and the modern circumstances as we go. And I've had a contribution to that, but many others have. And as I say, it's been in various different manifestos for the Conservative Party. So I couldn't claim sole authorship as much as you might try to flatter me to that extent.
Okay, well, that's very modest of you. Perhaps I can put it this way, and I'm really not trying to be cheeky or rude here, Lord
Right.
Chancellor, because you know that I very strongly believe in due process.
Yes.
And I very strongly believe that if accusations are made against a person, in any capacity, they should be innocent until proven guilty. But I need to ask you this because there is an investigation into a number of allegations against you at present. And as I stress, those are allegations, and I'm a great believer in due process and respecting the fact that one should wait till the outcome of an investigation before making a judgment. But I need to put this question to you. If for any reason you had to demit office, who do you think would take this bill forward?
I'm afraid there are a bunch of hypothetical questions which I'm not going to indulge you on. I've been clear on the claims made with regard to myself. I believe I've behaved professionally throughout, but of course I welcome, indeed I called for an independent investigation so that I could deal with them transparently, not through the tittle-tattle that's anonymously leaked to the media. And I'm very confident that the Bill of Rights is a government proposal, not my proposal. And we have collective responsibility on these things.
A moment ago you said that you didn't think the Human Rights Act was perfect. I want to put a quote to you from Lord Carnwath, the former Supreme Court Justice, who gave a lecture about your Bill of Rights proposals back in February of this year. And he said this of the Human Rights Act: it was a simple and elegant way of consolidating the Convention rights, the European Convention on Human Rights, within our own law, while respecting the key principle of parliamentary sovereignty. Would you agree or disagree with that statement?
No, I wouldn't characterise it in that way, but I respect the fact that he might. I mean, there are a whole range of other people who were involved right at the outset, from Jack Straw, David Blunkett, so very much Labour architects who disagree. So I don't think it is a partisan thing.
This is Lord Carnwath I'm talking about, the Supreme Court Justice, not a former Supreme Justice,
agree.
Not a Labour architect. I think he was thinking about it more as a constitutional lawyer, and he said it was a simple and elegant way of consolidating the Convention rights within our own law while respecting the key principle of parliamentary sovereignty. So it's not really a political proposition, it's more of a lawyer's proposition.
No, but there's been quite a few who have criticised both the Strasbourg and the wider UK application of human rights, including various QCs and previous law lords. Whether they agree with the Bill of Rights, I don't want to put words in the mouth, but the critique of the Human Rights Act and indeed the way we apply Strasbourg case law goes far beyond the political domain.
Okay. The independent review of the Human Rights Act, its terms of reference, didn't include replacing the Human Rights Act, and they didn't include the scope of the Convention rights. So it's fair to say that we don't have the benefit of the independent review's expert views on those matters, do we?
Well, I think actually, if you look at Sir Peter Gross's report and his panel's contribution, which was very valuable, they did cover quite a lot of the ground. And I looked very carefully at it. In some areas, for example, where they were proposing various different amendments at the European level, they probably went further than anything we've suggested in the Bill of Rights. But the reality is, I've taken the view, and the government's taken the view, that we need further reform on some of the issues that they considered but didn't recommend a particular outcome. Section 2 is a good example. And I think the case for amending Section 2 and Section 3 is irresistible. But I respect the fact. I'm sure you will. But just say I respect the fact that people take different views.
I was asking you something rather more specific, Lord Chancellor. I said the independent review, they were never asked to consider replacing the Human Rights Act, nor were they asked to consider the scope of the Convention rights. So we don't have the benefit of their expert view on that, do we?
Well, actually, if you look at it, I mean, I don't have it to hand, but I'm sure I could dig it up. Actually, they looked at quite a lot of. So, for example, they looked at.
Talking about their terms of reference.
Yeah, but they looked at all these things anyway. They looked at extraterritorial jurisdiction, for example. I think that's not a procedural thing.
Look at the scope of the Convention rights, Lord Chancellor.
Well, extraterritorial jurisdiction, I think, is the scope, the substantive scope, because it's the territorial scope. So I don't think that's quite right.
Talking about the Convention rights, from Article 1 through right to life, right to family. If they didn't look at the scope of those rights, because they weren't asked to.
Actually, if you look at the proposals for the Bill of Rights, not only are we saying a state party to the European Convention, but we also incorporate the Schedule of Rights. It's true in the procedural framework, we look at the way the UK interprets those rights, but those are fundamentally about those which are either derogable rights or rights which admit of qualification. For example, Article 8, but we don't touch Articles 2 and 3 substantively.
I'm not asking you about your consultation.
Yep.
I'm asking you about the independent review. Do you agree with me, and it's a matter of record, that their terms of reference didn't include replacing the Human Rights Act and didn't include the scope of the Convention rights? Therefore, while we have the benefit of their expert views on many other matters, we don't have the benefit of their expert views on those issues because they weren't asked to consider them.
No, because I think actually what they did was reach further and farther and did in fact delve into substantive issues, and I've given you an example of that, but we may have to agree to differ on this, Madam Chair.
They concluded that there were no significant changes needed to the Human Rights Act. That's correct, isn't it?
Well, they had a range of
3 small changes.
Recommendations. Okay,
3 small changes.
Okay, so they did recommend changes.
They concluded there were no significant changes needed to the Human Rights Act. That's right.
Look, I don't think it's news, Madam Chair, to say that I think we need to go further than Sir Peter's report, much as I hugely valued the insights and recommendations they made. But
you never actually responded to Sir Peter's report, did you? The same day it was published, you brought out your own consultation, and I think Lord Carnwath, to get back to him, described the 2 things as ships that passed in the night.
No, I consulted with Sir Peter. I had the benefit of his report, and I looked at it very carefully.
You didn't
and I discussed
publish
it with
a response to his report, did you?
No, but we've, in the response that we've done to the on all of the other things that we've been doing, including the Bill of Rights consultation, we've woven in our views on his report.
Okay. Looking at your predecessor, Sir Robert Buckland, he's described the Bill of Rights as a cure without a problem. What do you think of that?
I hugely respect Rob, and he's entitled to his opinion, but disagree with him in the way I've described. I think let me give you a few examples. I think the way we've had the combination of judge-made privacy law impinge on media freedoms. I think generally the pressure on free speech, something which actually, Madam Chair, you've spoken about I think very passionately, is a good illustration of where we've allowed the parameters of free speech to be narrowed, possibly more in practice than in law. I think the Article 8, the volume of Article 8 cases used to frustrate deportation of foreign national offenders is an issue. I think parole has become adrift from its moorings, and as I've said, I think we would need the Bill of Rights to effectively deliver the reforms that we've talked about, at least in totality. I also think in separation centres, dealing with the terrorist threat within our prisons, I think we need to address that, and the Human Rights Act is being used as one of the legal weapons to challenge the use of separation centres. So what I've tried to do is just give you the concrete examples of the things that I do believe need to be addressed and which the Human Rights Act is licensing litigation to prevent us from doing.
Okay, well, the independent review of the Human Rights Act concluded there were no significant changes required. Sir Robert says it's a cure without a problem, the Bill of Rights. But your own public consultation showed that not one of your proposals had wide support. That's right, isn't it?
Well, it depends who you're talking to, but of course, when you do a consultation like that, mostly you hear back from, if you like, the sector, the NGOs and those who either support the very elastic interpretation of human rights, which, as I said, I think is constitutionally wrong, as well as creating the practical problems that we've made. But that's natural. I mean, that normally happens with consultations in those sector. I think if you look at the broader public response, when people hear what we want to try and do, strengthen free speech, bring some common sense into the system in areas where we think it's been abused, and I've given the example of deporting foreign national offenders, I think it has widespread public support.
Okay, well, let's look at someone who's broadly on your side and taking the view that there has been, perhaps to use your words, an elastic interpretation of human rights. Lord Sumption, he's told us that the bill is singularly badly drafted. Have you got any plans to make amendments to fix the bill as it makes its way through Parliament?
Well, by the way, Lord Sumption is one of the, I think, most searing critics of the way Strasbourg, in particular, has operated in recent years. I think, in fairness, both the Supreme Court and the Strasbourg Court have shifted over time.
But I'm not asking you about that,
Lord Chancellor.
I mean, I agree with you,
Yeah.
and we both know that Lord Sumption is a searing critic of the Human Rights Act. But
Yes.
my question to you is, he has said, notwithstanding his concerns about the existing Act, that your bill is singularly badly drafted. And what I'm asking you is, and I'm keen to get an answer because we'll need to move on to some of my colleagues asking questions in a minute, do you have any plans to make amendments to fix the bill as it makes its way through Parliament?
Look, we'll go through Parliament in the normal way. If there are better ways of achieving our ends, and of course, whether it's in this place or I'm not quite sure where we are at this point in time, but whether it's in the Commons or in the other place, I'm very happy to look at those. And I've extended that invitation to Lord Sumption.
Good. Right. Can I just ask you about the convention itself before we move on to some more detailed questions about the bill? As you've pointed out, there's been various promises and Conservative manifestos over the years to reform the Human Rights Act. But back in 2015, when the Right Honourable Theresa May was Home Secretary, prior to the Brexit referendum, she said that rather than leaving the European Union, the UK should leave the European Convention on Human Rights and the jurisdiction of its court. And more recently, we have it reported that the current Home Secretary, the Right Honourable Suella Braverman KC, had said at an event at the Conservative Party conference that her position was that ultimately the United Kingdom needs to leave the European Convention on Human Rights. Now, I asked her about that today in the Chamber, if that was still her position, and she declined to answer. But yesterday in the Chamber, when the Prime Minister was introducing his statement about a new immigration law, a lot of your Conservative colleagues on the backbenches were calling for the government to derogate from the Convention. And again today, I think we had a question at PMQs about derogation, and the issue was raised during the Home Secretary's statement about the tragedy in the Channel. And I asked the Prime Minister yesterday if he would rule out derogation, and he didn't. So can I ask you this, what's your position about whether or not the United Kingdom should stay in the Convention?
But first of all, you're conflating various different things. Derogation is, of course, permitted within the...
I'm coming to derogation in a minute. I'm asking you about your position on staying in the convention.
Oh, I see. But you were asked... I'm sorry.
I was explaining
let us not conflate derogation.
Hang on a second, Lord Chancellor. I was explaining to you what's been said over the last couple of days and narrating to you
not
comments that have been made
you went back
in
to
the Chamber.
2015.
And I went back to what Theresa May said in 2015 and reminded you of what the Home Secretary has said. But then I asked you a question that was very specific. What's your position on staying in the convention?
Well, look, the government's position is very clear. We rule nothing out. Nothing is off the table for the future. And I've made the point that the Bill of Rights envisages us staying within the convention, and indeed the ECHR is included as a schedule. The main effect is to overhaul the procedural framework for interpretation, although it does have measures dealing with dialogue and the margin of appreciation. But that's the government's position, and I think it's entirely consistent with what both the Prime Minister and the Home Secretary have said.
That's very helpful. So your position is that nothing's off the table for the future?
I don't think any government can take things off the table.
You're not ruling out withdrawing from the convention in the future?
In the future, depending on the situation we find ourselves in, give the ebb and flow of the approach Strasbourg has taken, I don't think it's responsible for the government to rule things out. It is the responsibility of the government to do is make sure we deal with the big issues of the day. And one of the big issues, which our constituents feel very, very frustrated about, the situation with small boats. I think also...
Yeah, we've talked about small boats a lot, and I'm really conscious of the time.
Sorry,
hang on a second, Lord Chancellor, because when you wrote to us on the 14th of July, you wrote to me in response to my letter of 30th June as chair of this committee, then acting chair as I was, you said, our plan as a government is to remain party to the European Convention on Human Rights. Have you changed your position since then?
No, and if you allow me to complete what I was saying, the Bill of Rights envisages we stay in the European Convention. Indeed, we incorporate the Convention as part of a schedule to the Bill of Rights. But if you're asking us to tie ourselves down indefinitely for the future, no, that's not something we're willing to do. I think I'm known for many years as saying I think we can achieve most, if not all, of what we want to do so by asserting the margin of appreciation and changing the procedural framework. But I can't guarantee it.
Okay, that's very interesting, because when this committee went on a delegation to Strasbourg earlier this year, we met with many interlocutors who told us about how important they felt it was that the United Kingdom should remain in the convention because of the signal leaving would send out to other states, particularly Eastern European states. But we were told that UK ministers visiting Strasbourg have repeatedly assured various interlocutors at the Council of Europe that there's no question of the UK withdrawing.
Madam Chair, you've got a new government, a new Prime Minister, and we have the acute crisis we face in the Channel. I'm looking forward to going over to Strasbourg in the new year. I've always had a very good relationship with them. We want to stay within the Convention. No one is looking to trip up out of it. But I think we have to put the national interest first. That's the responsibility of any government.
Thank you. We're going to bring in David.
Thank you. I think we've certainly all heard loud and clear the government remains, certainly for the foreseeable, committed to the ECHR. We've also heard quite a few articulations about the idea of the need for a new global agreement around migration. Clearly in the drafting of the Bill of Rights, one of the things that might be under consideration is compatibility with future ambitions for what that might look like. So just interested whether you could say, has there been any discussion in international fora about what a successor agreement or set of treaties might look like? Is that something which government is thinking about?
So we, of course, engage with all our international partners. A lot of that is done by the Foreign Secretary, although all ministers have a role in it. I mean, I remember us having this conversation with respect to the Brighton Declaration, which we, and of course it was Ken Clarke and Dominic Grieve who pursued that at the time, who are not known for being sort of human rights hawks. And there's absolutely no reason why we couldn't revive those kinds of initiatives, whether it's at global level or at a European level. But I can't say that there is anything immediate on the horizon in terms of a protocol or something like that. But it's certainly true to say there's a lot of concern around some of these migratory issues and the feeling that the architecture that was set up in the post-war era is not reflective of the circumstances that we're seeing today. I think that must be true. Quite how we address that and whether we have a convention, whether we deal with it another way is an interesting question.
Thank you. Lord Singh.
Good afternoon, Lord Chancellor. I'm Inderjeet Lord Singh of Wimbledon, a crossbench member of the House of Lords. My question relates to international implications and interim measures regarding the proposed Bill of Rights. Do you think Russia should have been free to ignore interim measures of the European Court of Human Rights that ruled that they should not execute Aidan Aslin and Sean Pinner, two British nationals? And just to continue, Article 34 of the Convention provides that states must not hinder people effectively bringing cases to the Strasbourg Court. The Strasbourg Court has held that this requires states to follow interim measures. Do you agree that failure to comply with an interim decision of the Strasbourg Court of Rights is a breach of Article 34 of the Convention?
So, in terms of what Russia did, of course, Russia shouldn't be engaged in a substantive violation of human rights, and I think that's the fundamental point. Once you've engaged in the lack of due process and capital punishment, it seems a little bit niche to be pointing to whether or not they comply with an interim order, I would say. In relation to interim orders, they have an interesting history. Of course, interim orders, you refer to the Convention, are not actually a feature of the Convention at all. They're a feature of the rules of procedure. Rule 39 is a rule of procedure of the Strasbourg Court. It has no basis in the Convention whatsoever. And I think this is important. Indeed, the Strasbourg Court originally recognised that that was the case, and for long periods of its history, interim orders under Rule 39 were advisory, not binding. This is important. And then at some point, and I forget the exact date, but I could easily write to you with it, but it's in all the case law, in all the textbooks, the Strasbourg Court, of its own initiative, not because states parties in a legislative exercise of power gave them that right, changed their view and said, well, actually, we do think our interim orders are binding. So I think it's quite wrong, certainly if it happened in the jurisdictions of the UK, we would find it remarkable and unconstitutional for a court, through a rule of procedure governing its internal process, to abrogate, to take upon itself what is effectively a right of injunction. And so I think it is, and it wasn't intended by the Convention, it doesn't feature in the Convention, it is an internal rule of procedure of the court.
Hang on a minute, Lord Chancellor. The question was this, Article 34. Now, Lord Singh put to you that the Strasbourg Court have held that Article 34 of the Convention requires states to follow interim measures. Now, it's an interesting procedural history you've given us, but the fact is now that the court has said that Article 34, and I'll read it out to you, individual applications. The court may receive applications from any person, non-governmental organisation or group of individuals claiming to be the victim of a violation by one of the high contracting parties of the rights set forth in the Convention or the protocols thereto. The high contracting parties undertake not to hinder in any way the effective exercise of this right. Now, the court has now held that that means that the high contracting parties must obey interim measures. And if I may just query your comment that an interim measure, the interim measure of the court in relation to Aidan Aslin and Sean Pinner was rather niche. It was an interim measure that they shouldn't be executed. No, it's hard to imagine anything less niche.
You're, I'm afraid that that's not a fair characterisation of what I've just said. First of all, the appalling human rights abuses in that case, the substantive human rights abuses, were the principal issue at stake. But as for Rule 39 interim orders, a court cannot judicially legislate to give itself a power to issue injunctions. And
it hasn't judicially legislated.
It has.
It has interpreted Article 34 that the high contracting parties mustn't hinder effective exercise of the right to bring application. If you bring an application to do X, and effectively your rights are going to be obliterated in the meantime, then there can be no effective individual application without an interim measure. Now, you know that as well as I do. We're both lawyers.
Not only is it clear that what you're saying is wrong, It is the Strasbourg's court initial view was that their interim orders were non-binding and advisory only.
What about its current view, Lord Chancellor?
But look, you cannot. That's what I'm saying.
The law develops. The law is
cannot,
not stuck in stone.
No, it does develop, but it develops in this country subject to the oversight of Parliament. And what would be remarkable and indeed
develops in this
Sorry,
country.
can I answer your question?
Jurisprudence of the court
Sorry,
develops
can I answer your
law,
question,
but this is,
Madam
this
Chair?
is undergraduate law.
Madam Chair,
Parliament, it's the courts as well.
No, sorry. I think you're just fundamentally wrong about this, and we may have to agree to differ, but it is absolutely wrong for a court citing a rule of procedure of evidence to then create a power to injunct the executive. I think that's just constitutionally wrong, and it wasn't even the Strasbourg court's initial view. It took many years for them to flip from a view that it was advisory to a view that it was binding. And I think that's wrong.
You're talking about the history here. I'm talking about the current position, which doesn't relate to a procedural rule. It relates to an article of the Convention that the court have held that Article 34 requires parties to follow interim measures. That's the question that my colleague put to you.
I'm sorry. It is wrong for a court, through interpretation, to judicially legislate. That is at the heart of the constitutional strengthening the demarcation.
Do you think it's wrong for the court to interpret the Convention?
Sorry,
do you think? I'm astonished by this. Are you saying it's wrong for the Strasbourg court to interpret the Convention?
What I was saying is it is no, but there's a big difference between applying the law to the facts of a case and creating a power for yourself absent any democratic oversight, and particularly one as potent as a power of injunction. And I'm afraid in any other jurisdiction other than this, we would just be saying this is common sense. And the problem is it hasn't been done as a result of clear agreement by the states parties. And that is indisputable.
Thank you, Chair, for that. Just moving on very quickly, why are you proposing that the UK courts, why are you proposing to prohibit UK courts from having regard to interim measures of the Strasbourg court? Why are you proposing?
Because it's not contained in the Convention, and as I said, I think the assumption of that power by any judicial body is quite wrong, absent any democratic oversight.
Why are you prohibiting it? That question hasn't been answered.
Yes, I think it's wrong. You mean we could allow them just to take it into account? If we want to legislate to that effect, that's Parliament's prerogative, but we haven't. And it's quite possible that you have powers of injunction against the executive set out clearly in legislation, well understood, the parameters are understood, but those are decided by the legislature holding the executive to account. And I think that's right.
Thank you, Chair. That's an outright prohibition as far as I can see. Thank you.
Thank you, Lord Singh. Baroness Ludford.
Thank you very much, Lord Chancellor. I'm Sarah Ludford. I'm a Lib Dem peer. The bill removes the requirement in Section 2 of the Human Rights Act for court to take into account the case law of the Strasbourg court. Baroness Hale has said that Section 2 ensures the two courts, quote, speak the same language. Won't removing Section 2 lead to the Strasbourg court giving less weight to the reasoning of the UK courts?
No, I don't agree. I mean, Section 2, as it originally was envisaged, was a take into account provision. At the high water mark under Thomas Bingham in the House of Lords, and it was effectively an obligation to match the Strasbourg case law. Now, it's ebbed and flowed since then, in fairness, and I want to pay tribute to the current Supreme Court because I think they have restrained some of what I would consider, as a member of the legislature as well as the executive, some of the excesses of the past. But what ebbs may flow, and I think it is right to be more prescriptive about the canons of interpretation when taking into account Strasbourg jurisprudence. And there's an interesting interrelationship between Strasbourg and the UK courts, which I think is sometimes underestimated. The Strasbourg court doesn't have a strict doctrine of precedent, and most civil law countries don't, which allows their case law to be more fluid, I think is the kind way of putting it. In the common law system, and again it's different around the UK, we take case law as precedent unless it is overruled by subsequent precedent or by Parliament. And therefore what's happened is, with Sections 2, magnified by the impact of Section 3, which allows effectively courts to rewrite or amend legislation, is that you create a ratchet effect where the most elastic interpretations in Strasbourg become the threshold, the floor in the UK. And then under the Human Rights Act, and Article 8 is a very good example of that, what was actually happening under the HRA jurisprudence is Article 8, the parameters of which were expanding through judicial innovation, if I could put it like that. And actually Strasbourg at various points looked at this, thought, well, that's a prompt, if you like, for us to go further. Let me give you one very concrete example. The first time that the Strasbourg court used Article 8 to scupper deportation was in the mid-2000s, I think, from memory. That was very much prompted by the innovations in UK case law, which were allowing deportation orders, particularly for FNOs, foreign national offenders, to be scuppered on those grounds. So it's a good example of the push factor, not just the pull factor involved. But I think we need much clearer canons of interpretation. I think the replacement of Section 2 with Clause 3 of the Bill of Rights will help us achieve that.
Isn't a better way of describing what you've just said, or summing up what you've just described, rather, a creative judicial dialogue? Sir Peter Gross said of taking account of, you are not bound by it, but you must take account of it so that you have your link in. Why shouldn't you have that if you are a party to the convention?
Well,
I mean,
at various points, as I mentioned,
it's no big deal, is it?
No, it's just not factually accurate. Now, I'm not saying this is the position of the current Supreme Court, but if you look at the position under Ulla, the position that Tom Bingham took, this was not what he said. He said that effectively you needed to match the case law from Strasbourg, and I think it's a good example of where well-intentioned provision in the HRA...
We really moved on from Ulla.
We have,
yeah.
but
that's kind of history now.
It broke, don't fix it now, isn't it?
Sorry, let me answer one or other of you. I don't think that's quite right, because what ebbs may flow, and it's the same in Strasbourg. So I think you could argue that some people have said to me, actually, rather than you're tearing up human rights, actually, you're codifying the best practice that we've seen in the Supreme Court. Fair enough. But what I do think is right, given that ebb and flow, which is so important on the canons of interpretation, that we provide a clearer framework. And that's all Clause 3 does.
Okay, can I move on to Clause 3? Clause 3.3a would limit the power of domestic courts to interpret convention rights more expansively than the Strasbourg court. Won't this disempower our courts and give the final say on the meaning of convention rights to Strasbourg? And perhaps with the Strasbourg court less inclined to give a margin of appreciation to the UK courts?
No, I don't think so. But what it will do is encourage the UK courts to adopt a more autonomous approach to the interpretation of case law, bearing in mind the other factors listed in Clause 3, and in particular allow them to divert from Strasbourg case law, again noting the point I made earlier, that the case law in Strasbourg is often quite haphazard. A good example of that is prisoner voting. I can think of a whole string of the cases from Hearst through to there was an Austrian case and then others, which jumped around the place quite a bit. So I think it is absolutely legitimate for us to say, well, we want an autonomous approach, and given that the Strasbourg case law often differs with itself, there is a power to diverge from it, which is Clause 3.3b. And also, we ought to be very careful in thinking that again, we come back to this ratchet point, thinking the Strasbourg case law, when it is pronounced, is treated like precedent. It isn't in Strasbourg, and we shouldn't treat it as such in the UK.
Just before going on, if you've raised prisoners' rights, and I can't resist, because it obviously has an iconic symbolism in certain quarters, but I think it has been much misrepresented. The Strasbourg court did not say all prisoners must vote. It said the UK should adopt a scheme for prisoners to vote, distinguishing between different categories. So I just permit me that comment. My question is...
Can I address that point?
Yeah.
Because I was the Human Rights Minister in 2015 and 2016, and they did at various points hint that they would accept giving a cohort of prisoners the vote. But since when was it the court's role, again, there was no right of prisoner voting in the Convention, to engage in what is effectively not just dialogue but a negotiation? And actually, as we've set out in various points in the Bill of Rights, it was something where actually, notwithstanding the controversy, we had a decent dialogue with Strasbourg. And I remember going and speaking to the Committee of Ministers, and we very respectfully said we didn't want to trip up out of the Convention, but we felt that this judgment was wrong. We felt that the Strasbourg case law had changed and shifted so fluidly that there couldn't have been a huge amount of confidence in Strasbourg in it. And respectfully, we didn't want a particular fight about this, but we were not going to give prisoners the vote, and Parliament had decided that. And actually, that's a good example of where, notwithstanding the judgment in Hurst, that we engaged in dialogue, and we haven't given prisoners the vote. Everyone told me at the time we'd be kicked out of the Council of Europe. We weren't, and prisoners still don't have the vote, and that's why I think we can feel confident in the approach we take in the Bill of Rights, and availing ourselves of the margin of appreciation and engaging in that conversation, that dialogue with Strasbourg.
Okay, an alternative interpretation would be that the system worked. But let me go on to my last question.
It's not far from what I've just said, actually, but we had to work pretty hard, and at the time, everyone was saying, I mean, if you like, that dialogue that we had with Strasbourg on prisoner voting is some of the clauses here in the Bill of Rights will help facilitate that. I certainly think we've got here a provision which says when you have an adverse ruling, it should be notified to Parliament. Parliament should take its responsibility to look at those issues very seriously. But we also affirm the fact that in Clause 1 that judgments from Strasbourg cannot affect the right of Parliament to legislate. And I think that's an important point of principle.
Okay. So my last question is, the principle of subsidiarity means that the UK has primary responsibility for enforcing and securing convention rights domestically. But the bill seems likely to increase the number of cases going to Strasbourg. How is this compliant with the principle of subsidiarity?
I'm not convinced that it will have that effect. I was looking at Keir Starmer's textbook on this subject from 1999, which was quite interesting. He wrote, "The court is primarily concerned with supervision, and the role is therefore subsidiary to that of the domestic authorities. It has no role unless the domestic system for protecting human rights breaks down." I think he was right about it then, and that's basically the model that we adopt. I think we are entitled to engage in dialogue with Strasbourg, and I think as the malleability of the case law has shown, when we engage positively, as we did on prisoner voting, I think we can push back. And I don't think that. Of course, there'll be cases that will go to Strasbourg from time to time. That is not an unhealthy part of the relationship. But I don't foresee a big ramping up of the cases.
You're talking about how things have worked well under the existing law, the Human Rights Act, but you're proposing to abolish the obligation of domestic courts to take account of Strasbourg case law and limit their power to interpret convention rights, as you put it, more expansively than the Strasbourg court. So the risk is, isn't it, that there's going to get a gap? You want an originalist intention of interpretation of the convention. So the danger is of a gap between Strasbourg court and the domestic courts, and that could generate an increase in motivation of people who feel they have not got full interpretation according to what the Strasbourg court would say in the domestic courts, and therefore might give an impetus to more people to go to Strasbourg, whereas at the moment not many cases go to Strasbourg, and of those the UK wins most of them.
Yes, I don't think that would fundamentally change. We've got an excellent record, and I think that would long continue. I mean, I was looking at the record of adverse judgments against the UK by year. The average was 24 between 2000 and 2010. The average between 2011 and 2021 was 6. I think we've got a stellar record, but I also think, on issues of fundamental importance, whether they're constitutional or public protection, it's right that we engage in that dialogue. I don't view, first of all, I don't think the floodgates would open in the way that you're suggesting. Secondly, I do not think when there is a very important principle at stake that it is in any sense illegitimate. In fact, I think it is legitimate for us to push back in Strasbourg. And sometimes those cases are the vehicle for doing so.
Thank you, Lord Chancellor.
I'm going to come next to Bel Ribeiro Addy. Thank you.
Thank you, Lord Chancellor. I want to take you back just a little bit. You were explaining earlier about where your views on changing to this Bill of Rights have come from. Now, you understand that the Human Rights Act in this country is kind of lauded as a model statute right across the world, and Sir Peter Gross's review has confirmed that they only want minor changes, not a wholesale destruction, which it seems as if you're proposing. And you've explained again that several Conservative Party manifestos have made reference to these changes, but the most recent one was in the line of Sir Peter Gross's review, in that just minor changes need to be made. Now, given that review, the language in your most recent manifesto, I just want to understand where you believe that the mandate comes for your government to make such sweeping changes to a vital piece of legislation that has such widespread support across the country and across the House.
Well, I don't think it does have widespread support across the country. No one in my time as Foreign Secretary ever said to me, do you know what, we love the fact that the UK has got the Human Rights Act. And indeed, when you look at the way other systems work, few would allow the kind of blurring of the separation of powers that we have. In terms of where the mandate comes from, I mean, we mentioned the previous manifesto commitments. This one is entirely consistent with what we're doing in the Bill of Rights. I mean, actually, we get, in one sense, we have the Goldilocks criticism, where some people say we're going too far. Other people say we're not going far enough because we don't talk about pulling out the ECHR. But actually, I would say that this was the next chapter in our approach to human rights, which strengthens the quintessentially UK freedoms like free speech. We recognise jury trial, again, something which is part of the right to a fair trial, but not particularly common on the continent, with some exceptions. And then we curb some of the abuses, which undoubtedly have taken place. I think this is a good, common sense reform. And the fact that you get that Goldilocks critique, I think, shows you how moderate the approach we've taken is.
Well, I'm going to move on to ask you some questions about public authorities and positive obligations.
Yes.
As it stands, the bill you're proposing would limit the ability of the courts to apply positive obligations, and these have been instrumental in the past in ensuring that the police effectively investigate loss of life. For example, the Hillsborough inquest and serious violence against women and girls, with the example of the rapist John Warboys. So why would you want to weaken these rights and protections for these groups of people?
Well, so nothing in our proposals would have prevented the Hillsborough inquiry. And you mentioned, I think, John Warboys as well. Again, the same thing. But generally speaking, in relation to positive obligations, we come back to the same point at which I was discussing with the chair. It cannot be right as a basic matter of constitutional principle, that we allow a court to decide what is effectively a legislative matter regulating what our public service bodies do. And I think there are a whole range of problems with that. For example, adding on regulatory straitjackets. The obvious example I've given in the past is the Osman ruling. Now, anyone that read the Osman case from the 1990s couldn't help but be moved by the case that happened. But what we've done is create a positive obligation to, which sounds as a matter of operational policy sensible, to tip off those who are at risk of life or limb. No one would disagree with that. But when you then find out that it's become a straitjacket regulatory requirement to tip off anyone who, without discretion, who faces risk to themselves, and then you see the proportion of resources, and we document it in the consultation, that various different police forces have had to go through to protect gangsters from each other, you realise what the problem is with positive obligations. They effectively are a licence to provide a straitjacket obligation onto public service bodies. That's if it should be done, it should be done by Parliament. You emasculate the ability, for example, of a chief constable to decide what is the proper use of resource to pursue the public interest in prosecuting one or other different priority. And I mean, the National Police Chiefs Council have highlighted the increasing resource burden of positive obligations. Now, and again, as I say, I've looked back at the consultation document where we looked at the other police forces that found that they were increasingly required by threat to life notices to protect gangsters from each other. I just don't think that that's what the business of the courts are. What we've taken, though, if you look at the Bill of Rights, is quite a practical approach. So you've got post-commencement interpretations of the ECHR, where we say that the courts are not required to apply positive obligations. And then the pre-commencement ones, we just say you don't have to apply them, and you can give great weight in a string of circumstances, so that you must give great weight to the ability of a public authority to perform its functions. We must allow the police to decide operational priorities. We shouldn't be affecting the operation of primary legislation. I would gently put the question back to you. Which of those things do you think a court should be able to overrule in the imposition of a positive obligation, which by definition is not grounded in the Convention?
Hang on a second. It's not really for members of this committee to answer questions. You're here to answer the questions, Lord Chancellor. And I think we'll stick with the questions which Bell is asking, if you don't mind.
Okay, well, let me just say rhetorically then, I think that I would be fascinated to hear from the committee which of paragraphs in subparagraph 5.2, which of the criteria A to E you think that we shouldn't be having courts to consider.
The committee's questions, please, rather than questions
actually,
to the
Madam
committee.
Chair, it is squarely addressing the question that I've been asked.
We have very limited time. And this is a very important issue because, as we've heard, positive obligations meant that the Hillsborough inquest went ahead, meant that the black cab taxi rapist was properly dealt with after a long delay, and so on. And so I'd like you to focus on the questions that my colleague is asking, rather than putting questions back to the committee. Otherwise, we won't cover any of the ground that we've got to cover this afternoon.
I respectfully differ, and I will reserve the right to express myself in the most effective way and give the fullest answer I can. All I'm saying is, feel free to come back with the specific elements of our approach to positive obligations that you feel are unwarranted.
I think you've given some quite extreme examples there, but throughout everything you've said today, it strikes me that you don't necessarily feel that all rights should apply to everybody equally. So I want to ask specifically on the right to life, do you feel like that right applies to everybody equally?
Of course, it's the question of whether a right to life, which, as we said, I said earlier, we in terms of the substantive rights, we do not alter or seek to affect, but whether it should be expanded to, as indeed a range of other convention rights have been done, to provide positive obligations on the state rather than requiring the state not to interfere with those rights of an individual. And that is it's one of the tools, along with sections 2 and 3, that have been used to effectively allow court innovated regulatory approach to be imposed on the state without any democratic oversight. And I think it is fundamentally undemocratic.
You do not agree that one of the primary functions of a state is to use its powers and its resources to keep its citizens, regardless of who they are, alive?
I do, but I also think the ordering of the public service priorities, the allocation of funds between them, and the judgment of the professional, whether it's police officers or other public service providers on the front line, is something that should be overseen by Parliament. Of course, the executive should apply the law to them, and if there are regulatory changes or additional burdens, that should be done by Parliament, not the courts.
Okay. Threat to life notices that are issued by police directly are done when there's real and immediate threat to a person's life. As I said, some of the examples you've given are quite extreme. And in evidence to us, the Centre for Women's Justice have said that threat to life notices have undoubtedly saved women's lives. Do you agree with that assessment?
No, look, what is saving people's lives is the police. And the question that you have in all of these cases is, are the police being required, through the lens of a ruling that's been decided by lawyers in a court, an adversarial rather than a polycentric environment for policy making, are they being given the latitude, but also the oversight, to discharge their mandate to protect the public? And I think if you look at those areas where, as a result of threat to life notices, you say it's an extreme example, but it's just a very clear one, where police officers have to expend a significant amount of their time, and I can give you the detail that we had which was set out in the consultation paper. But I think if it is wrong for a court to require or impose a regulatory burden, which I'll give you the example we gave. In Greater Manchester Police, in 2014 to 2015, had two separate operations over a significant period of time. One lasted 18 months, during which the force issued 100 threat to life notices. Again, this was all between rival gangs. Now, I'm not saying that shouldn't be policed. It should be policed and policed robustly. But those operational decisions should be decided by chief constables. And I think the lens of a courtroom looking to the future and trying to regulate is entirely wrong. I think it's wrong on principle.
Given that we know politicians are flawed in themselves, as are the police, for the moment we're seeing, at the moment we're seeing a situation where the Metropolitan Police itself is in special measures, other public bodies are. Who else is going to regulate this if not the courts?
It should be done through acute accountability. We've got obviously independent police complaints mechanisms, but of course...
which people have very little confidence in.
No, I understand. But ultimately, we as parliamentarians need to step up to the plate. But just think about it...
You have little confidence in parliamentarians as well.
But I don't think they have confidence that the court can act as a regulator in the sense not of checking abuse by the executive, including the police. That is absolutely its role. But then to engage in what is effectively licensed by the Human Rights Act, providing a regulatory burden or regulatory measures. I don't think that's right. I don't think anyone would say that was right. But we do that implicitly, which is why we have taken the approach on positive obligations in the Bill of Rights that we do. Of course, we need to have robust accountability of the executive and the police and anyone else to the courts. But that's different from giving the courts a regulatory function. And effectively, in practice, that's what the Human Rights Act has done, and it's wrong.
The main example you've used is people involved in criminal activity, and what you're proposing is to limit the ability of the courts to interpret convention rights in a way that would require the police to protect the lives of people involved in criminal activity. Wouldn't your proposal also apply to children involved in said activity, such as county lines? And why would you want to exclude such children from protection?
What you're saying is fundamentally misrepresenting of my view. I don't want to exclude anyone. I don't even want to exclude the police from tipping off serious criminals from threat to life. I'm not trying to exclude it. I'm just trying to prevent them being required in a regulatory fashion to do so by a piece of, effectively, a ruling of a court which has not taken into account all the different competing priorities, operational and otherwise, and the finite resources that any police force has. That's the bit I think is wrong.
If they're not required to do so, how can we guarantee that they will do so?
Look, that's why we have PCCs, that's why we have Parliament, that's why we have proper mechanisms for oversight of the executive and the police. The courts are there when they stray beyond the law, but that's different from making the courts a regulator, and that's the fundamental difference.
Now, the law's not there to ensure that all of these bodies act in the way that they're meant to, and the courts to enforce that action.
The fundamental difference between us, and I don't think it's that much, is that the courts are there to interpret and apply the law. They're not there to legislate or regulate.
Those are all my questions for the moment, Chair. I do have some further questions, I think, later.
Yes, would you like to come in with those now?
Yeah, I can.
Just before you do, Belle, can I just try and understand something, Lord Chancellor? In the Warboys case,
yes,
the common law would simply have said that how the police investigated was up to them. But because of the positive obligations in the Human Rights Act, the court held that there was a duty to investigate effectively. And that meant that the crimes of a serial rapist were brought to light properly, investigated properly, he was imprisoned, and that the Met changed the way that they investigated sexual crime. Now, when Professor Mark Elliott gave evidence to the Justice Committee, he said, and I quote, "It seems clear that the kind of positive obligations that War Boys enforced would affect the police's ability to determine their own operational priorities. My assessment," and that's Mark Elliott's assessment, "is that judgments like War Boys would be much less likely under the Bill of Rights." That's right, isn't it?
No, I don't think so. And if you look at the detail of the clause on positive obligations, I think that's apparent. But I do think more generally, encouraging litigation against the police is not a particularly effective means of the oversight that we all want. And that's I mean, don't get me wrong, I'm not saying it's unnecessary, but the risk, of course, if it is shifted from holding the police to account when they have broken the law to trying to regulate them prospectively, the risk is that you will skew the operational priorities that only a chief constable in the last analysis can decide, and skew the resources so that you have disproportionate focus on the one or other case that has had the fortuitousness to go to court, rather than being looked at in the round. And that's the thing I think we need to be careful of.
I see. So the Bill of Rights will discourage litigation against the police. Thanks. I've got a note of that. Thanks very much, Lord Chancellor. Belle, do you want to continue with your...
Thank you very much, Chair. Lord Chancellor, I want to ask you some questions about deportation and immigration. You were already quite clear about your views on the use of the right to a family life, and Clause 8 would restrict the ability of an individual to challenge deportation legislation on the basis that is incompatible with the right to a private and family life, unless the legislation would cause extreme harm to the individual's family member. Wouldn't this effectively extinguish the right to a private and family life in all of those cases?
I think you get a sensible balance, not allowing serious offenders to claim spurious elastic rights to stay in this country when the public interest is overwhelmingly in removing them. And often it's in the family members who they're trying to coercively involve in the proceedings. It's often in their interest for this individual to be removed. So no, I think it gets the right balance.
In a lot of these cases, sometimes we're talking about people that have been here for a number of years, in the case of foreign national offenders. Some of them may have been brought here when they were young. Some of them may have even been born here, just not had their citizenship regularised and their immigration status regularised in the way that it should have been. And we've at times proposed sending them to countries that they probably left when they were very young, or maybe have never even been to, and away from their families. Do you think that's right?
Yeah, I think if they've burgled, killed, raped or committed other very serious offences, I think the public interest, if they're not a citizen of this country and citizenship does mark something important, I think it is right.
Even though our nationality and citizenship department is clearly flawed?
Look, no government body is perfect, but I stand by my view that if you commit a very serious criminal offence, I mean, in some of these cases, I remember there was one case several years ago where the individual had paid no maintenance, had committed very serious crimes, had previously been convicted of battery against a partner, and yet was claiming the right to family life to stay. I mean, actually, this is the kind of stuff, if I may say so, that gives human rights a bad name. And so, yes, we want to make sure. And by the way, none of this was Article 8. If you look at the Travaux Préparatoire to the Convention, it was never envisaged that Article 8 would apply in such circumstances. So not only do I think you have quite a pernicious set of circumstances, something like 80% of successful human rights appeals against F&O deportation orders are Article 8 now, and yet this was never envisaged to apply to that set of circumstances. I think it's right in the Bill of Rights. You know, we're not talking about eroding things like Article 3, the prohibition on torture. We don't go near that. I think that's right. I believe in moral absolutes. But I do think in some of these areas, the thing has just become adrift from its moorings. And a lot of people will I remember I had an individual whose brother had been killed and dumped in the River Thames. She was, I believe, Nepalese, came and saw me in a constituency surgery, and I explained that we weren't able to deport the perpetrator because of the right to family life. And she said, but what about my family's rights? I didn't have a very good answer to that, and I don't think we do unless we correct this.
How is Clause 8 compatible with your obligation to secure convention rights, including the right to a private family life for everybody? Yet again, it seems that you're saying not everybody has a right to a private and family life.
Now, if you look at Article 8, paragraph 1 sets out the right and paragraph 2 sets out the qualifications to it. So all we are doing is applying an interpretive framework which I believe is consistent with that. But I'm sure we'll end up in dialogue with Strasbourg.
Because you would be restricting who it is that has this right to a private and family life, so effectively saying it's not a right that you believe is universal to all.
No, I'd be saying that the right to family life doesn't allow a murderer, a rapist, someone that commits armed robbery to claim loose social ties or family ties to stay in this country, and that's exactly what the article. There's no doubt that Article 8 was never intended to be the goalpost to shift to cover that.
Again, you seem to be using some of the most extreme circumstances when a lot of the cases that we see as parliamentarians come through our inboxes or that we are contacted about, more generally we hear about, aren't about that. We have situations where the Home Office, recognising that somebody has a right to a family life, is telling them to raise their child via Skype. Do you think that's correct?
Look, it's for the Home Secretary to talk about the Home Office. I think the Home Office would be supported in the very difficult and important job they do if we had a legal framework that allowed them to focus on the areas where we want to protect rights and be compassionate and not allow those rights to be abused. And that's why I think this is important.
I want to go on to how you believe that the Bill of Rights will help solve the issue of small boats crossing the Channel. You told the Justice Committee that you thought the Bill of Rights would be able to help with this, and actually you mentioned this earlier when you were answering questions to the Chair. Which clauses in the bill do you think will help resolve this issue, and exactly how will they do that?
So first of all, I have never said that I thought they would solve small boats. I've said I think they could help materially in about 3 or 4 different ways.
Your words earlier to the Chair were, I believe, they would address it.
Yeah, but it's not the same thing as solving it, and I was very clear. I remember I've been clear about this all whenever anyone's asked me.
You specifically quoted as saying to the Justice Committee that it will help in some material respects to solve the small boats problem.
Exactly what I just said to you, but it won't solve the whole problem, and indeed we should be very clear that on the things the Bill of Rights will and won't do. But you asked me a specific question. I think clauses, the approach we take to sections 2 and 3 of the Human Rights Act, the approach we take to interim measures in clause 24, the approach we take to legislative, primary legislation enacted by Parliament in clause 7 of the Bill of Rights, I think in all of those ways, both indeed, so the 3 key ways, interim measures, which we discussed at some length, section 2 and 3, stopping the effectively judicial, the creative judicial reading down or amending of legislation, and then the greater respect for Parliament or the greater weight given to Parliament in certain areas, which is set out in clause 7.
Thank you. I did have one more question for you about the Belfast and Good Friday Agreement, because obviously you'll know that for us in the Labour Party, it's one of our proudest achievements in government having delivered that, and the ECHR and the Human Rights Act are the scaffolding that holds this up effectively. The Northern Ireland Human Rights Commission have advised that the bill appears to be incompatible with the obligations under the Belfast and Good Friday Agreements, and to incorporate the ECHR and provide direct access to the courts. Do you not believe that this alone should be enough for you to withdraw it?
No, the Bill of Rights is consistent with the Belfast Agreement because we stay within the Convention and we incorporate, as I mentioned, the ECHR as a schedule to the Bill of Rights, and that's what the requirements are.
But if you stay within the Convention, just for the sake of doing so, as opposed to actually complying with it fully, is it not just us having our cake and eating it and not living up to what we're meant to be following in terms of what the spirit of the ECHR was meant to be with the Belfast and Good Friday Agreement?
No, I just don't accept that. I don't accept we'd just be staying in either the spirit or the letter. We'd be fulfilling our obligations. But one of the prerogatives we have is to engage in dialogue with the Strasbourg Court. And I think if you look at the what Robert Spano, he's stepping down now, has just stepped down as president of the Strasbourg Court, has said they've entered an age of subsidiarity, whereas before they used to talk about the age of the living instrument. I think they are signalling, and this is partly reflection on the Brighton Declaration and the movement to have less creativity in their own case law. I think they're signalling that it's absolutely perfectly legitimate for us to engage in that dialogue.
How can we be doing this, specifically in terms of the Good Friday Agreement, if we are failing to incorporate the ECHR and provide direct access to the courts?
Sorry, it's what you're saying is factually not true. The Bill of Rights incorporates as a schedule, it's in fact Schedule 1, Part 1, the Convention. It's in there, so it does incorporate the Convention.
Those are all my questions, Chair.
Thank you so much. But if withdrawing from the Convention is not off the table, as you said earlier, if we withdrew from the Convention, the United Kingdom, that'd be a big problem for the Good Friday Agreement, wouldn't it?
I think it's right for the government to be clear that, first of all, our focus is on the public interest and the national interest, and for that reason nothing is off the table for the future. But in terms of the Bill of Rights, in terms of what we're saying now, we've been very clear that we would stay within the Convention and that we've incorporated it as a schedule to the Bill of Rights.
I hear you, Lord Chancellor, but the question I asked you was this: if the United Kingdom withdraws from the European Convention on Human Rights in the future, that would be a big problem for the Good Friday Agreement.
I'm not going to engage, Madam Chair, in hypothetical questions.
Might have to wait until Ireland's reunified before we do that. What do you think?
I'm not going to be tempted down.
Okay, David, please go ahead.
Perhaps shows more of your prejudices than mine.
Well, it's not prejudice, it's just perhaps looking into the future. You're looking at the possibility of withdrawal from the ECHR. I'm looking at the possibility of what might protect the United Kingdom from being held in breach of a very important international treaty.
Well,
David.
Let's agree to differ.
Thanks, Lord Chancellor. So the questions I'd like to put to you are about the relationship between the UK courts and Parliament, the balance which has been much referred to. Starting perhaps with the Independent Human Rights Act review.
Yes.
Concluded that, since 2004, there has been no real evidence that UK courts have misused Section 3. So I'd just like to ask you, what's the motivation really, given that point, for repealing Section 3? And given that the government could bring legislation forward to overturn any bit that it didn't like, would that be a more constructive way forward rather than remove it entirely?
We set out in the consultation doc the areas where Section 3 has been a problem. And I understand the argument that actually the court's approach has ebbed and flowed over time. But precisely because it has ebbed, it may flow again in the future. And I think it is fair on an issue so critical to the separation of powers to have clearer canons of interpretation prescribed in our fundamental human rights law. And I think it's just wrong. I mean, it's just wrong to licence a court to amend legislation. And I'm not blaming the courts for it. If you do that, they will follow the parliamentary prescription or requirement. I just think it's wrong. I think we need a clearer demarcation of the separation of powers, and that's what the approach we take to Section 3 and indeed Section 2 will achieve.
Thank you very much. Turning to Clause 40 of the bill.
Which one?
It's Clause 40, I think we're talking about.
40?
Yes. Which provides that the Secretary of State can make regulations to preserve or restore judgments in which the court have relied. Clearly there's been a great deal of debate about the importance of parliamentary sovereignty in this context. I think my question is why the argument is that it should be the government, in the person of the Secretary of State, that makes that decision, rather than it being a matter for Parliament about which judgments should be preserved or not.
Well, ultimately, it would have to be done by, I think it's done by regulations, and I'm just looking. So it is subject to. And it's a good point, and we did consider this at length. The regulations would be subject to parliamentary oversight, and any that amend or modify primary will be subject to the affirmative procedure. So when we looked at this, I did feel confident that the parliamentary prerogatives and the way, and I've talked about this at length at various different points, is there. I mean, that's what I think this one thing the Bill of Rights does unequivocally is reassert not just the rights but the responsibility of Parliament to engage in this, including adverse judgments we get from Strasbourg.
Just doing that a little bit, how confident would you be that Parliament has the capacity, the opportunity, the scope to undertake that scrutiny to the appropriate and necessary level?
I think we should feel confident. I mean, let's have a look at it since October 2000, when the HRA came into force. 46 declarations of incompatibility. 40 have been fully addressed. There are 6 still ongoing. 3 would be addressed by remedial orders currently before Parliament. 1 the government has already said we will address by remedial order, and I think that leaves 2 subject to appeal. I think that's a reasonably robust mechanism that we've got in place, and that's why I haven't suggested changing any of that.
Thank you very much, Steve. And final question from me. Clause 7 of the bill suggests that the courts will be required to accept that the balancing between policy aims and convention rights is something always properly carried out by Parliament. Now, Lord Pannick was very critical of this position, essentially the argument being that it's just an attempt to take power away from the courts. I just wonder if you have a view about the appropriateness of the need to strike that balance through that clause.
Of course, we want to set out that when it comes to determinations of the public interest, and sometimes the substantive articles of the Convention make reference to it, I think great weight should be applied to the decisions that Parliament makes, particularly when they affect policy aims rather than executive action, let's say. The balance between the rights of different individuals or indeed different convention rights, and we've talked a bit about free speech versus right to privacy. I mean, I think if Parliament has opined on the right balance between those two, that's something that should be respected, rather than what we've had in the past, which is opaque and sometimes expansive interpretations of the right to privacy through Article 8 used to erode that determination by Parliament. It'd be different if we were talking about Articles 2 or 3. But I think in those other areas, it's absolutely right.
Just to probe this a little bit further, so I think we talked a lot about small boats and the debate about migration, legal or otherwise, has gone on, which could potentially be an interesting example where strong views have been expressed by Parliament, including on occasion ministers at the dispatch box. But the aims that are set out by ministers are not reflected in the law. And clearly we've heard frustration from ministers about the decisions of the courts, but it is clear that the courts are following the law as opposed to the policy aim that is set out. So could you just perhaps give us a degree of assurance that due legal process will still be the absolute backstop in this context, as opposed to an opinion that might have been expressed in Parliament that is not perhaps reflected, for example, in legislation?
I think you're absolutely right. Look, if the executive behaves in a way which is beyond the law, the court must hold it to account. But this isn't actually, Clause 7 is about something rather different. It's about when there is a decision to be made on the right balance between competing rights or competing policy aims. And where Parliament has got a set position on this, I think all we're saying is that the court must have regard to it. It's not binding it, it's not extinguishing the court's discretion. But we set out the principle in Clause 7(2)b that the court in those kind of circumstances should give the greatest possible weight to the principle that in a parliamentary democracy, decisions about how such a balance should be struck are probably made by Parliament. I mean, the truth is the courts say this kind of thing all the time, and they do indeed in Strasbourg. What we want to make sure is that this is a canon of interpretation rather than just something that is said now and again, but often actually departed from in practice under the HRA.
Thank you, David. Lord Henley, thank you.
Thank you, Chairman. Lord Chancellor, can I move on to parliamentary scrutiny of human rights? And the first point is that in your bill, you're removing Section 19, which imposes that duty on ministers to certify this bill complies with, and all ministers take that very seriously and take advice on it. But at the same time, in your letter of the 14th of July, you made a commitment that the proposed legislation will be accompanied by an analysis of human rights implications. Now, if Section 19 is game, presumably the government are not going to be certifying the bill is fully compliant. At the same time, you're proposing something rather different. But are you proposing something in legislation? Are you looking for an amendment here? Are we getting less parliamentary scrutiny or less advice from ministers as to what is in any proposed legislation?
I'm glad you've asked the question. I think it's a very pertinent question. I mean, if you look at the requirement from Section 19, it's not something that comes from the Convention. It was regarded as a practical means for ministers to vouch that what they were doing was consistent with the HRA and indeed ECHR. Yeah. The test in practice is whether it's more likely than not that the bill would withstand legal challenge on convention grounds. It's effectively a 51% test. Now, there's a number of, I think, arguments against that. But first of all, what about cases which might be of the highest importance? Let's say they affect public protection, counter-terrorism powers. We've anguished about this a lot, where there's a 45% to 50% prospects of success. I think there's an argument there that we want to be less small c conservative in our approach to litigation and avoid a binary test. I think you can argue that that's had a chilling effect, not just in big areas like CT, but in other areas where we wanted to innovate legislatively. But unless we can hit the 51% threshold, that very binary threshold, we are have our hands tied. There are also a range of cases where, to put the other argument, we've had all sorts of legislation where a Section 19(1)A statement has been made, but the legislation was declared incompatible. I was looking at some examples, so the Safeguarding Vulnerable Groups Act 2006, the Anti-Terrorism, Crime and Security Act 2001, there are others. And so I think the approach that we would take this is not to have such a binary approach at the 51% threshold, but actually to have government bills still accompanied by a human rights analysis, which would set out our view of the law. I think that's right. So we're not. I don't think that will reduce scrutiny. I think, if anything, it will encourage a more granular and nuanced debate about where the edges of the law are and where we're entitled to engage in dialogue, and frankly, where we aren't. And as I said, there's a string of cases of legislation where we've had adverse judgments, notwithstanding Section 19(1)A statements. So I've discussed this with various colleagues in government, and across Whitehall there's a feeling that Section 19(1)A threshold is too binary. But that doesn't mean there won't be a proper human rights analysis when legislation is introduced. I hope I've explained the thinking clearly enough.
But you won't suggest that should be part of the bill itself, that there should be that analysis?
No, but I'm happy to make a commitment to that effect.
That seems fine. You've also accepted that the Bill of Rights...
At the dispatch box. I think with all of, I'm happy to be clear on what we envisage as a matter of practice. Sorry.
No doubt it will come up in the passage of the bill through both houses, and assurances will be given of the right sort. You've also accepted that the Bill of Rights will increase, or likely to increase, the number of declarations of incompatibility issued by UK courts. Now, is that going to leave victims without any effective remedy for breaches?
You can make an argument that it would strengthen accountability. But in any event, it's the proper constitutional approach.
Good. And then finally, Clause 25 imposes a duty on the Secretary of State to notify Parliament of any adverse Strasbourg judgments. And the director of the Bingham Centre for the Rule of Law told us that any parliamentary discussion without adverse judgments should focus on how the judgment should be implemented, and not whether it should be implemented. And again, and can we have assurances? Will we have assurances? Government won't try and use parliamentary debates on this to avoid abiding by adverse judgments.
Look, it is the prerogative of Parliament to decide how it legislates, and it cannot tie its hands, and it shouldn't tie its hands. But what we're signalling here, and this was very much born out of the experience of prisoner voting, and one of the arguments that was made to us is, but has Parliament properly considered this? Is this just an oversight? Because a lot of the legislation on barring prisoners from voting was so old. And we made the argument, hold on, Parliament has considered this, and there were various different debates. I remember the backbench business debates on this, Westminster Hall debates. But this is done out of respect and as a platform to allow for that kind of dialogue, but also because it was asked explicitly of us, but has Parliament really considered this? And so it should give some comfort to Strasbourg that we are properly engaged in dialogue and that Parliament is not ignoring their rulings.
Thank you very much, Lord Henry. Lord Dobbs.
Thank you. Lord Chancellor, Clause 15 would introduce a permission stage preventing victims bringing human rights claims if they cannot show that they've suffered a significant disadvantage. Why should a victim of a human rights violation find it harder to enforce their rights than someone who's experienced negligence or breach of contract?
You have to show loss if you want to bring a negligence claim and a contractual claim. But I think it's absolutely right that there's a permissibility stage at the Strasbourg Court. It's a different one, but I think that it is the right thing to do, and actually we should all want the courts to be dealing with the most meritorious and substantive claims. And secondly, in the examples you've just given, there's always a test of loss before you can't proceed without demonstrating loss.
Well, the Ministry of Justice has referred to the fact that the Strasbourg Court imposes a similar test for applicants. Lord Mance has said that this ignores the difference between first instance access to justice and review jurisdiction. Isn't he right?
No, there is a difference between the two courts. All I'm saying is I think when you want to bring a human rights... people would find it extraordinary, Lord Dobbs. You and I have been debating this long enough. But people outside of Westminster find it extraordinary on the issue of human rights, the most central violation that could be made to any citizen or anyone else in this country, that you can bring these claims when you haven't suffered any material disadvantage. It's extraordinary.
Okay. Well, Clause 18 requires courts to take into account a victim's past conduct when awarding damages. Will this essentially lead to courts having to distinguish between worthy and unworthy claimants? And doesn't Clause 18 in fact undermine the principle that human rights apply to everyone?
No, because this is at the remedies stage, isn't it? The damages stages. It's explicit. In fact, it's in the title of Clause 18. And what it's saying is, and there's long been a principle that he or she who comes to equity must do so with clean hands. When you want to apply for compensation, it's quite right that a court takes into account what you did. Was it contributory to the wrong that you say you've suffered? We have that in negligence. I think it's right that we have it in human rights cases.
Well, my last one is this. Clause 18 will also require the courts to give great weight to the importance of minimising the impact of damages on the ability of a public authority to carry out its functions. Isn't the best way for a public authority to avoid damages simply to comply with its human rights obligations?
Yes, but what we want to avoid is litigation being used as a tool to paralyse public bodies that are doing important roles. So I think both of those tools, both of those facets are important. I don't disagree with you. We want public bodies performing their functions lawfully, compatibly with human rights. What we don't want is to encourage a litigation culture. And I think that it's right that the courts take that into account. They do at the moment, but do they give great weight to it? I think it's something whereby a factor that we're reinforcing rather than inventing in clause 18, para 6.
Thank you.
Ernest Rodford.
Lord Chancellor, can I just pick up on something you said when Lord Dubs was asking you about the term significant disadvantage? I mean, it may just have been, in a sense, a slip of the tongue, but your reply referred to the fact that you wanted a victim to be able to show material disadvantage. I mean, thinking back, because we spent quite a lot of time as a committee on what happened in care homes during COVID. If a family member was unable to visit their loved one because homes were applying restrictions which they shouldn't have done, I mean, has that person suffered material disadvantage when they were unable to be present when their loved one died?
I'm not going to try and, certainly as Lord Chancellor, give comments on hypothetical cases that haven't been brought. What I'm saying is, and I should have kept a significant disadvantage rather than material, because it could of course be non-physical,
Emotional.
for example. Say again?
Emotional.
It could be emotional, yes, absolutely. But I do think it is right, if you're bringing a human rights claim, that you've suffered some form of significant disadvantage or harm. I think most people would find that axiomatic in a human rights case.
Well, I won't continue, but I mean the contrast is made with other types of claim, and then it's for the court. Surely, I might be going above my pay grade here, but then it's for the courts to decide in the redress and any damages or whatever, rectification that they order, how, and they will, take a view on the disadvantage. But what you're introducing is a permission stage, which doesn't apply to other causes of cases of litigation. But I mean, you replied to.
I think it would be extraordinary if we got down the end of the track of a case, and then we discovered, okay, well, you can make some technical argument around rights being violated, but actually it didn't do you any harm.
Surely in the court's consideration of the case, they are not going to entertain trivial cases. I mean, that's their role, is to adjudicate on what the impact of a human rights breach has been and what the redress is for it. I mean, you're just introducing a complication and a delay and cost.
Far from it, we're doing the opposite of that. We're making sure that a court can make that preliminary judgment up front, precisely to avoid the cost, the time, the wasted effort of proceeding with a case where at the end of it there is no significant disadvantage. I think most people would think that was common sense, but we may have to agree to differ.
If you think it's common sense, Lord Chancellor,
yes.
Why aren't you introducing a similar permission stage for people who've experienced negligence or breach of contract?
Because look, I would need to look at how comparable that was. But what we're saying this is really in relation to effectively public law proceedings, and I think it is right with the level of, if you like, the hierarchy of claim that we're talking about here, a human rights claim, over and above any other claim under UK law that the individual may have. To say that if you want to make that argument, you need to at least be able to show significant disadvantage. I would want to think, before giving you a substantive reply, why we would approach that differently, because negligence is a private law rather than a public law claim.
Well, staying with public law, the convention, which we are a signatory to for the time being, although you've told us that withdrawing from it's not off the table, but we're still a signatory to it, and as you've reminded us, the Bill of Rights is going to import the entirety of the convention into domestic law, as the HRA currently does. There's no test or the convention doesn't contemplate any permission stage for a first instance domestic claim. And I think the full point that Lord Mance made was that the European Court of Human Rights test for permission stage is for review at the international level. The European Court of Human Rights doesn't contemplate there would be any permission stage at the domestic level. And therefore the argument you're making, the Ministry of Justice, by comparing your domestic level permission stage with the Strasbourg Court permission stage is just really a spurious point, because admissibility criteria commonly differ at first instance and on review. That's the case, isn't it?
Well, I accept that they are. I accept they are different. Well, the point I'm making is I don't think it's illegitimate or inappropriate if the Strasbourg Court has a permissibility stage for a human rights claim for the UK courts to do so. And in a way,
Strasbourg Court's looking.
Sorry, I answered the point.
It's on review, but this is really important because this isn't my argument. It's Lord Mance's argument. He's making the point that admissibility criteria commonly differ at first instance and on review. Now, presumably, you wouldn't disagree with that.
No, I can understand that, but I don't think it is.
Do you disagree with it?
No, I don't. I'd need to consider it at length before deciding whether I agreed or disagree with it. But the point I'm making is, actually, often the human rights argument is tacked on the end of a string of other claims that may be made against the public body. And I'm not saying that that's right or wrong, but it is, if you like, the kitchen sink which is thrown in with it. I think given all of the other claims, it is legitimate to say that the court should have a permissibility stage in relation to the human rights element.
When you say it's the kitchen sink, you're a lawyer like I am. You know that the
recovering lawyer, Madam Chair. I'm a recovering lawyer.
Okay, well, I'm kind of a recovering lawyer as well. But the point is this. The Gay Cake case, which you'll remember, a recent decision of the Supreme Court, made it very clear that if you haven't pled the human rights point at first instance, you can't throw it in at the last minute. So that's why people plead it from the beginning, isn't it?
Yes, and that's fine. I mean, there's that point and the approach we take with the permissibility stage, I think those two points are entirely complementary.
David.
Very brief question, Chair. We talk a lot about parliamentary scrutiny in the UK context. I'd just like to ask you what weight you give to the scrutiny provided by the Parliamentary Assembly of the Council of Europe and the other bodies of the Council of Europe to the operations of the Convention. I suspect some of the issues that we've discussed here and that have been aired may arise from political pressure brought from that Parliamentary Assembly. Clearly, we have UK members who are part of it. As a JCHR committee, we met the Legal Affairs Committee in Paris earlier in the week, so we've seen a bit of their operations directly. What weight do you give to that scrutiny on the operations compared to the scrutiny of the UK Parliament or other parliaments over it?
I think it's important. I have to say I have welcomed engaging with the Committee of Ministers. I'm only done it once, but when I go out I will engage with both bodies. I'm rather a fan of the Council of Europe. I think they do important work well beyond the human rights realm. What we want to do is to make sure that the Strasbourg Court is operating in an effective way and is sticking to its mandate, precisely because we're not looking to trip up out of the convention. So I don't feel any nothing but warmth, and I remember as Foreign Secretary trying to use the Council of Europe and these other bodies. For example, we had issues with UK citizens abroad not having due process rights in one or two countries, and therefore trying to make sure that the convention rights in practice were being respected in some of those countries where young people go and get into trouble, may get arrested and locked up, but are they actually being treated properly? So, and it was a good place to do it without some of the sensitivities that if you raise the issue on a bilateral level you might encounter. So I think the Council of Europe has its place and does some important work.
Can I ask you some questions about devolution, Lord Chancellor? And you have been very generous with your time.
I was just thinking that.
And, we may disagree about many things, but I think we can agree that you've been extremely generous with your time. We're very grateful to you for that. So I might just wrap up with a couple of questions about devolution, if I might. Bell asked you some questions earlier about Northern Ireland, so I'm going to focus on Scotland and Wales. But I think it's fair to say from the evidence we've heard, both orally and in writing, the Bill of Rights Bill has been met with significant opposition from key stakeholders and office holders in Scotland, Wales and Northern Ireland. For example, the Scottish Human Rights Commission has said that the bill, and I quote, relies on false premises instead of evidence and has been developed without adequate consultation or scrutiny, and that it would, quotes, significantly undermine rights protections for people in Scotland. Can I ask you why you're pressing ahead with legislation that's not supported in the devolved nations?
I think it applies. I think that proposition is variable depending on where you go and who you talk to. But what I would say is, first of all, I've engaged with all of the executives across all the devolved administrations, all of the legislatures. We've talked to academics, we've talked to practitioners, and it is a UK-wide piece of legislation. And I believe it yields significant dividends in the way I've described, which will benefit everyone across the UK. The Human Rights Act is a UK-wide piece of legislation. It's a protected enactment, and therefore repealing it, replacing it, changing it in any shape or form is a matter for the UK Parliament. And I say that without prejudice to the devolved competencies in that area as well.
Thank you. I mean, Professor Aileen McCard, Professor of Public Law at Durham University, she gave evidence that this Bill of Rights will engage the Sewell Convention, and so therefore it would be normal for the UK Parliament to seek the consent of the Scottish Parliament. And this committee has given its view that the government should seek the consent of the Scottish Parliament and indeed the Welsh Senate. Do you agree with that?
Yes, we will.
And if that consent is withheld, will you respect that decision?
Well, I don't want to get ahead of where we are, but I made the point that it's a UK-wide piece of legislation and it's a protected enactment under the devolution settlements. But let us not prejudice the engagement, because actually it's important and we have taken it very seriously and assiduously up until now.
I hear you. I mean, it's just the reason I'm asking the question is that in recent years there's been a number of occasions in which the Scottish Parliament has withheld consent to legislation and the British government have gone ahead with it. But recently we've heard the new Prime Minister say that he wants to reset the relationship between Westminster and Holyrood, and that the union between Scotland and England should be collaborative and constructive. Do you agree with me that those aspirations would involve respecting the decision of the Scottish Parliament to withhold consent, if that were to be its decision? And let's be honest, the arithmetic is such that that will be its decision.
I don't agree with you. I do agree with what the Prime Minister said, and that's the way I would intend to proceed.
Okay. Just briefly, you previously told us it was possible that the bill would lead to divergences in the laws across the nations of the United Kingdom. And now the bill's actually been produced. Can you tell us which exact provisions in the bill may lead to divergences and how you would manage that?
I don't. I'd need to look again at the context of what I said before. But no, I think the whole point is it's a UK-wide piece of legislation. What I respect is that there's variable geometry under the existing devolution settlements and in terms of the devolved competences, which can affect how rights may be applied in practice. I mean, effectively, and you see this in other jurisdictions, the human rights constitutional federal legislation sets a floor, not a ceiling, and therefore within the devolved competences you would have the right to go further. That would seem to me axiomatic as well.
And of course we know that the Scottish Government already does have plans to go further, because it's planning a human rights bill that will incorporate socio-economic rights.
And I make no comment on that.
Different directions of travel, perhaps.
Look, I think
the two governments.
I don't want to be respectful, because there's not. I remember studying at university the argument about economic and social rights. For me, I think that those economic and social questions, finely balanced, polycentric rather than adversarial, all about the allocation of precious financial resources and social priorities, are precisely the stuff that elected politicians should decide. But there's plenty of people from Marx right the way through to social democratic politicians who disagree.
Including the founders of the New Republic of South Africa, people like Albie Sachs. Yep, would disagree with that.
Yeah, I mean, there are plenty of others around the world who would make that argument. The problem with it is, effectively, it's an attempt to shoehorn things that you can't get through an elected House of Commons, or if you're not in government you don't feel you can achieve, by the back door. And the risk is that you get a very skewed approach as a result. because the important thing with economic and social competing priorities is to be able to look at them in the round. But look, in a way, it's academic because we're not doing it here.
We're not doing it here. We're not doing it at Westminster. It's going to be done in Edinburgh. But I think it's only fair to mention for the record that our predecessor committee, of which Lord Dobbs was a member, back in 2008, produced a report setting out, looking at these arguments very carefully and setting out how socio-economic rights might be included in a British Bill of Rights without prejudicing political decisions. But I really don't want to go down that rabbit hole just now, unless Lord Dobbs wants to come in and...
I was going to say, I think you were on the committee at the time, but I don't think you went on that visit to South Africa.
I've been many times, but not with you. Unfortunately, I missed out on that one. A rare point of disagreement between me and Lord Dobbs. I normally agree with him on most things.
I think it was that visit to which I was referring when Albie Sachs told the committee that a country that has given up on socio-economic rights has given up on aspiration.
Well, I would fundamentally disagree with that. I mean, the ANC is a pretty left of centre, shall I say, body, maybe putting it rather mildly. I think if you believe in small L liberal democracy, you want the most finely balanced, shifting over time, norms, policy issues, social mores that affect the public purse. You want them to be decided in the round in Parliament, but I fear I'm going round the same track, and you've been very patient with me.
Well, you've been very patient with us, and we're very grateful to you for your very generous time giving. Not many ministers come for more than 2 hours, and so we're really grateful to you for that. And I want to thank you for your evidence and formally close the meeting. Order, order.